everybody. Hopefully you're all in the right place. This is the UDC Law Conversations with Clinicians final event of the fall 2022 semester. The purpose of this series really is UDC clinicians, today Professor Ieshaah Murphy, engaging in conversations with leaders in the experiential education field. As early leaders in clinical legal education, we are hoping to create a space where clinicians across the country can engage in topics of interest, along with thinking through some of the most pressing issues facing our community. So welcome. For anybody joining, we typically do cameras off until the end when we open things up for Q&A, and then we'd love you to come on the screen and ask questions and join us. But today, I am thrilled to introduce you to UDC Law's new criminal law clinic director, for those of you who haven't yet met her, Professor Ieshaah Murphy. So under Professor Ieshaah Murphy's leadership, the Criminal Law Clinic combats mass incarceration and racial injustice in the criminal legal system through direct representation, community engagement, and strategic action. Prior to joining us at UDC Law this fall, Professor Murphy practiced as a civil rights attorney and public defender. Most recently, she was at the ACLU of Maryland as a senior staff attorney focusing on racial justice and criminal legal system transformation. She was also at PDS, the Public Defender Service for DC, for over 8 years as a trial attorney, where she represented hundreds of children and adults charged with serious offenses. And honestly, her experience is really too much for me to share with you all now, and I hope that some of it will come up in this conversation today. But she frequently devotes her time, energy, and expertise to training lawyers and law students on various topics related to criminal defense and trial advocacy, including through the Harvard Law School Trial Advocacy Workshop, as teaching faculty with the National Criminal Defense College, several other places. She is also a founding member of the Black Public Defender Association, BDPA, where she develops and leads race equity trainings at defender offices around the country. She was a Gates Millennium Scholar, a Dean Scholar, and a valedictorian at Spelman College, and she received her JD from Harvard. So Professor Murphy will be in conversation with Professor Kristin Henning, our guest today. So Professor Kristin Henning is a nationally recognized advocate, author, recently, trainer, and consultant on the intersection of race, adolescence, and the policing of Black youth. She's the Bloom Professor of Law and Director of the Juvenile Justice Clinic and Initiative at Georgetown Law, and she previously was the lead attorney of the Juvenile Unit at PDS for the District of Columbia. So Kris, or Professor Henning, I should say, has been representing children accused of crime for more than 26 years and is a co-founder of a number of initiatives to combat racial justice in the juvenile and criminal justice system, including the Ambassadors for Racial Justice program and a racial justice toolkit for youth defenders. She also trains state actors across the country on the impact of racial bias on youth in the courts and has received several awards, including the 2021 Leadership Prize from the Juvenile Law Center and the 2022 Women of Distinction Award from the American Association of University Women. Professor Henning has written many articles and other publications advocating for reform in the juvenile legal system. Before we went on camera, we were just discussing her new book, The Rage of Innocence, How America Criminalizes Black Youth, which has received rave reviews in the Washington Post and the New York Times Book Review. The book was actually awarded a 2022 Media for a Just Society Award by Evident Change and the 2022 Social Justice Advocacy Award from the In Margins Book Awards Committee. So without further ado, I will pop off the screen and hand it over to Professor Murphy to kick off this conversation with Professor Henning. And thank you both so much for being with us today.
Thanks, Lindsay. Professor Henning, I am so excited to have this conversation with you for my own selfish reasons, because many of the questions I ask, I want to know. But I think that it is also, your wisdom will also be appreciated by law students, practitioners, other law faculty. So I'm so happy that we get to have this conversation. And I want to start off by kind of asking you a foundational question about how you kind of came into clinical teaching. I know I'm a new clinician. I just started in July. My path to clinical teaching was not intentional at all. And I would not I would not encourage other people to just kind of, not be intentional about it now that I know certain things. But I always think it's helpful to hear, kind of different people's stories and kind of what happened that led you to this space. So if you could share with us your journey, that would be great.
Absolutely. And thank you so much. First, Lindsay, for the introduction and for having me. And Ieshaah, I feel equally excited to be in conversation with you. I've gotten to know you through BDPA and through PDS. So it's just, it's great to be here with you. And yes, like this question about how do we all end up here? I got to tell you, I'm one of the few people that I don't know that I would say I was intentional about becoming a clinical law professor really early, but I was enamored with the idea of clinics before I even went to law school. I remember reading law school websites and application materials and just being excited about the opportunity to advocate for social justice and to represent real clients in law school. So I only applied to law schools that had a clinical program in the first place. And then in that very first week of law school, we had an ethics workshop that was taught by one of the great clinical professors of all time, Jean Peters. And she used a hypo in that ethics workshop from one of her children's cases. And it was like, from that day, I wanted to be Jean. I used to tell people I'm going to be Jean Peters one day. And so, ultimately I ended up being a clinical professor. But I was also fortunate enough to attend law school in a jurisdiction that allowed students to practice under the student practice rule as early as the second semester of the first year of law school. So I ended up doing 5 semesters of clinic, and hands down, clinic was the most rewarding aspect of my law school experience. And I knew then that I really wanted to replicate it for other law students, like at some point in my life. And so as I approached graduation, my professors kept telling me about the Prettyman-Steeler program at Georgetown. And the Prettyman program, I imagine, most folks on the call know, I see a lot of friends and even former Prettyman, Katie Cronick is there. And I see Paul Lee, former Georgetown, but and Marcy, a lot of folks. But anyway, the point being, for any students who are watching this, the Prettyman program is a 2-year clinical fellowship program. First year of the fellowship, the fellows learn how to try criminal cases. And then in the second year of the fellowship, the fellows continue to represent clients while also supervising students. So I guess, Ieshaah, by that point, I was pretty intentional about wanting to be a clinical professor. And I was looking for those opportunities, and people, my mentors definitely pushed me in that direction. And then I went to PDS because after I did 2 years of the fellowship, I was very clear that I did not want to go straight into clinical teaching without more on the ground experience. And so I was very intentional about going to PDS. I was there almost 4 years. And then I came back to Georgetown as a visiting professor. So, that's sort of my trajectory. It became.
I love that. I love that. I love it. And one of the things that I struggled with, I've always loved teaching. I've always loved training, right? One of the things that I struggled with when deciding to leave PDS was like this idea that I would be removed from practice, from advocacy, from clients, right? Even though I loved teaching. And when we first decided to, kind of invite you to this conversation, it was a no-brainer that we would talk about your book, right? But I also wanted to talk about the fact that you have just managed to stay connected to practice in a way that I think is just so useful for students, for practitioners, et cetera, right? And for me, you really kind of exemplify what it means to kind of use scholarship as a form of advocacy, right? And so you do so much. I can't even, I can't list all the things you do, but a few of those things: training across the country, training practitioners, training judges about racial bias and other topics, the racial justice toolkit, teaching, people, giving them resources about how to litigate race, the ambassadors for racial justice, right? training youth defenders and youth advocates to really insert race into their advocacy. And of course, your book, right? And all these things that's advocacy, right? That's ways to evoke change. And so can you talk about how you prioritize all of these things? And, like, in addition to your teaching responsibilities, right? In addition to your responsibilities to the university, like, how have you managed to do it all?
Yeah, I got to tell you, we chatted before, so I knew you were going to ask this. You made me do some hard work in my head, thinking about what am I doing? How am I doing all of this? And I'll say a couple of things. One is that listening to you just now is that this notion of what it felt like to leave PDS and to go into teaching. I absolutely love teaching, absolutely love being with students, but I also knew that I couldn't leave clients either, at least not yet in my career. So clinical teaching, talk about no-brainers, clinical teaching was a no-brainer. That's where I was going to go to teach. But it is really, so I have been representing clients now for about 26 years. And what I found was that it is really, really hard to do this work as long as I have without wanting to blow up the system, right? Like, especially, in DC, which I got to say, DC is a better place to practice than a lot of places. But even in DC, like watching Black child after Black child after Black child coming into the courthouse. I mean, you don't see white kids, this, Ieshaah, like we don't see white kids. It's just like, it's jaw dropping. And so I think you asked, like, how do you end up doing it all, is because doing it for 26 years and not seeing white kids in the system, you have to start figuring out how we're going to change this. Like, you can't tolerate it. So all of the work that you just listed, the trainings, the racial justice toolkit, the ambassadors for racial justice program, writing, has all been around that central agenda of pushing racial justice in the juvenile legal system. Really, because I was going insane. Like, it cannot be statistically possible that white children never commit crime. And we know that's not true. So I think that's what it's about. And so you talk about really staying close to the ground. So not only by continuing to represent clients, but then also thinking about who are the key players in the system and how do I get in touch with them? So it is truly getting in front of judges all across the country and prosecutors and defense attorneys to help us think about how to push the envelope on this racial justice question, is really what it's been about. And you talk about how do I prioritize it? I'm going to be honest, I still prioritize clients first, students second. That sounds blasphemous on a clinician's call. But here's what I have to say about that. To me, they're one and the same, because in order to ensure zealous representation in our clinical programs, that means we are pouring into and cultivating excellent students. So it ends up being parallel, right? And not so blasphemous as it sounds at first blush. And maybe other people don't think it's blasphemous. I mean, I think we're in the business of providing wonderful representation to indigent clients with phenomenal students that we work with. And so, but prioritizing means that, I can only do trainings, after hours. I can only do trainings, on days when I don't have class. I can only do peripheral work when it doesn't interfere with a court hearing. I will say the pandemic has actually made it a lot more possible to do even more trainings and speaking engagements than I used to, because we can do court hearings. Some of our status hearings are still on Zoom, so I can be in Idaho and in court with one of my students, because it's a virtual hearing, and I'll prepare the student, meet with the student before I leave town, but I can do the hearing there. So I'll stop there.
I am so happy you said that. The clients are first, because like, coming from PDS, that is how we look at the world, right? And so, like, the clients are first, period. And then transitioning to clinical teaching, it is, my priorities are still, the client, right? But I also have these students. And so I'm happy that you put it in that way, right? Like it is, you're helping students by prioritizing the client and by teaching them this client-centered form of practice, which
that's absolutely right,
which they take on to when they go out into the world and practice.
That's right.
So I want to highlight that you have been doing this work, kind of litigating race, training people, training defenders to litigate race, like for a while, for before, George Floyd was murdered and we had this racial reckoning, right? You have been like in the trenches doing this work, which I think is so important. And like you said, what you see in DC and the youth justice system is just, significant disparity, right? I think you say you have seen maybe 4 or represented 4 white children in your 25-year plus career. In the 8 years I was there, I'd never seen a white child, and I've never seen a white child, right? And if I had seen a white child, I'd have been like, what did they do, right? Like, because that would just be crazy to see a white child, right? And so one of the things that I think your book does, The Rage of Innocence, How America Criminalizes Black Youth, is that it highlights this huge disparity, this huge issue, with Black youth, right? And it puts it kind of on a national scale, and you use your personal experience, which is powerful, right? It's not just statistics. It's a practitioner who's represented hundreds and hundreds of clients who is telling you white kids don't come into the system, right? And you kind of give attention to this issue in a way that is real. I'm wondering, when you decided to write this book, what were your goals? I imagine that was one of the goals, but what was your goal, and are you seeing it happen? Is it what you had hoped it would do?
Yeah, it's a great question. As I listen to you, it makes me think of something that's really worth sharing with this community in particular, which was, when I started writing the book, I realized that for almost the entirety of my career as a youth defense attorney, that I was keeping a shock and awe folder. And so, like, what in the world does that mean? Back in PDS, when we were still using paper, yes, I have files full of police reports and old case files, but I was keeping a shock and awe folder. Now it's electronic. What is that? That is all of those cases that really stood out to me as absolutely disturbing for one reason or another. Why is this child being prosecuted? How did this happen? Why is the system responding in that way? So when it came time, and I'll tell you how I ended up writing the book, but when it came time to write the book, I realized I had all these stories saved up from shock and awe. And so I now have started saying to students, we should all, to help make sure we never become complicit in this system, that we should all keep a shock and awe folder. All those things that are outrageous that are happening to us. So anyway, I got invited to write a chapter of a book, Policing the Black Man, which was edited by Angela Davis, who many people on this call know, over at AU, and I wrote a chapter on policing Black boys. We had a 25-page limit, and I realized, oh my, there is so much more to say. So that's actually where it started. And you say, what were my goals? My goals were to give voice to the actual children who were being impacted by this radically disproportionate practice, this radical criminalization and over-policing of Black children. I wanted people to hear those stories. I also wanted the average lay reader right, to see themselves in the stories,
Mhm.
right, and be able to say, oops, I remember when I was a teenager, I did that myself and I never got arrested, or to see their own children in that. The other thing that I wanted to do was recognizing that anecdotes are not going to win the day for lawmakers, judges, politicians, those non-lay readers. And so I wanted to weave in some of the research, right? The research on trauma, the research on racial bias in very plain language so everybody could understand it. I wanted to weave in some of the data demonstrating that this is not a DC problem. I'm not just talking about DC cases, but as you said, it's a national landscape. So I was trying to do that. And my rationale was that stories change hearts and minds, right? That people aren't going to read an academic text, aren't going to read about social science and be moved, but stories will change hearts and minds. And that for those folks who were resistant to the anecdotes, they would also have the data and the science to back it up. And so I wanted to change hearts and minds. I want to see radical shift in policy at the police level, at the court level, also culturally, right? The reimagining or re-understanding of Black children, or stated differently, this is a shifting of the narrative of the ways in which we see Black children. I want readers to see Black children as children too. And so the question is, do I think it's having an impact? I will say yes. And in part, right, my book, first of all, it was probably well-timed whenever it came out, because this is such an important issue. But the fact that it came out on the heels of 2020, right, and all that was going on with the racial justice, the race relations, the tense race relations between police officers and Black and brown communities, the timing was exceptionally well placed, just by coincidence. And yes, I tell you, my opportunity to get in front of state actors, whether it's testifying before city council, whether it's being invited by courts to write amicus pleadings, whether it's being an expert witness, whether it's being invited to train in mandatory judicial trainings in various states across the country, all of that has quadrupled, is probably an understatement. And so that's one way in which I feel like it's having an impact. I've also finally started seeing state high court opinions coming out, citing to the reasonable Black child, which was an article that I wrote before the Rage of Innocence. So we're starting to see a shift in that. The Racial Justice Toolkit, we are seeing more and more defense attorneys across the country filing pleadings that add racial justice in their cases, and then giving us sample pleadings that we can then share out with the rest of the country. So there's a lot of stuff. There's been legislative advocacy, efforts to decriminalize some normal adolescent behaviors like disturbing schools and disorderly conduct, those little things, right? We're also seeing some shift in the ways in which Black and brown children who do commit serious crime on the back end, the way those children are being looked at differently for sentencing. So those are just some ways in which you're seeing some shift, but people are open to the conversation right now.
I love that. And I think that what it does is it brings the conversation to the forefront, because it's so easy to get desensitized, especially if you do this work, right? When I started at PDS representing children, I remember walking into the courtrooms and seeing, little kids shackled in chains, right? And it didn't matter what they were charged with. It didn't matter, most of them were not charged with very serious crimes, and they were, shackled, right? And that's when you see that, as a lay person who doesn't deal with, with the criminal legal system or the juvenile system on a day-to-day basis, that's shocking, right? Yeah. But when you work in that system and you constantly see it, it can be easy to kind of just, this is just what it is. This is normal. And I love how you've challenged us to not, this is not normal, right? We have to talk about it and we have to do something about it. So I'm sure your students, I'm sure, love you, and they learn so much from you about, practice, about just how to be client-centered, zealous, compassionate advocates, right? How have you managed, if at all, to include your students in these efforts over the years, in the various forms of advocacy that you've been able to engage in?
Yeah, I think that also is a fabulous question because it's one that we struggle with. We talk about it a lot in our juvenile justice clinic here at Georgetown, and for a number of reasons. One is because the trial work, right? Our clinics sign up to represent clients in, in direct representation in delinquency cases, and that is often on a different time schedule or timeline and a different pace than policy work, right? And so we have tried, actually, we even tried during the pandemic to have our students work on both a policy project and trial work. And we found that, it's hard, like those, from PDS, like, emergencies pop up and then the policy work gets pushed to the side. What I have learned, for those of you who don't know him, I co-teach now with Eduardo Ferrer, who's a phenomenal clinician, and he leads our policy side in addition to doing the direct representation. And I learned from him just how much the policy work can have emergencies. Somebody puts forth a bad piece of proposed legislation, you've got to respond immediately. And so there's that competition. So that was one hurdle that we have really tried to grapple with. And I'd love to hear actually from other folks on the call who've maybe figured out how to do it. So, we've thought about, well, maybe we could do alternating semesters, but really we love the fact that we have a year-long clinic where students really get to do litigation over the course of a year. And I think that's really important for youth clients who need that long-term relationship development. So I'm a little hesitant to sort of trade that off. Also another challenge, it's not even a challenge, this is a blessing, is that at Georgetown, we have policy clinics. And so students who are really gravitating towards policy work can go do that work. And sometimes we collaborate with the other policy clinics. So when students sign up for our litigation clinics, we want to make sure we give them that experience. So all of that being said, we do integrate the students into the work, all of the different types of work that you just talked about, the trainings that we do and the resource development, the amicus pleadings that we do in other states. And we do it in a couple of ways. One, we have students at Georgetown who serve as RAs, research assistants for the clinic, separate and apart from clinic students. We've got law clerks during the summer and during the academic year. And what we have found is that many of our clinic students, right, who are doing the direct representation, sign up to play one of those other roles, who have a special interest in it. So they might be a summer law clerk for us in the summer preceding their clinic year. Or they might sign up to be a research assistant and do our clinic while also being a research assistant. So those students sort of self-select into this work. And there's a lot of ways that we engage students in this. We've had students help us with the training curriculum. They've helped us creating annotated bibliographies of the research that defenders and lawmakers and judges can use, that social science research in their legal pleadings. Students help us summarize a lot of that. Students have partnered with us on amici pleadings, which has been really great. When, let's say, one of their trial cases goes away early, they get a good, a dismissal of a case, they might come in and work with us. So we bring them into some of this other work. And finally, the final thing that I'll say that I think really is relevant for this crowd is that in our seminar, we build in these conversations about policy reform. And from day one, we teach our year-long clinic in 4 frames. And I think this is different even since Katie and Paul were in our clinic, but we teach our clinic in 4 frames. And the 4 frames are racial justice, trauma, understanding that so many of the children that we serve are experiencing trauma. So it's racial justice, trauma, adolescent development, and gender. And we are convinced that you can't teach criminal law or youth legal justice without those 4 frames. And so we're very intentional about it. We have seminar classes set aside specifically for those classes, but in addition, we weave that into all of the other classes. So if we talk about the 4th Amendment, we're not going to just talk about the 4th Amendment. We're going to talk about the 4th Amendment and race and gender and adolescence, right? And trauma, and how all 4 of those are relevant in every single class: interviewing, disposition planning, everything that we do. But so we're very, very explicit about all of these questions in the seminar that accompanies our clinic.
I wrote that down because I am going to steal it.
Yes.
What I love about that is, you've trained the Black Public Defender Association trainers. I've been in your trainings, which are super just like, eye-opening and life-changing in terms of how I do trainings, right? And what I find is that, there's offices will reach out and they'll ask, like, how do we litigate race? Can you do a training about race, right?
Yeah.
Like, how do we talk about race? And I love that you are integrating, race, trauma, all these things into everything, right? Because that's how it has to happen. It can't be like this one training about race and here you have it all, right? It is integrated throughout all of the topics, right? Because it does matter to everything. You can't understand, any topic related to youth justice without understanding race and how
That's
it connects, right?
Yeah. And I'll say this to you. I mean, like, I'll be honest, like when I started doing the work, I wasn't as intentional about it. And it really, I was trying to, be honest with myself. When did I really, really, really get intentional about talking about naming the role of race? And it probably, even though I've been practicing 26 years, it probably wasn't like till about 8, years ago that I became intentional about it. And I think in part, it was some out of fear, part because you and particularly as a young lawyer, you're so like you're dedicated to learning the craft, right? And it representing individual clients as a zealous advocate. And I think we get a little bit of tunnel vision. We're not thinking about the big picture, but the second you step back and you look at it, you can't then not turn away, right, from the critical questions. And so I just wanted to own that. Right?
And there's also this understanding, right? Like within, when I was at PDS, like we knew the system was racist. We knew like it's only Black kids. We knew all of this, right? But it wasn't, we weren't kind of using that to say, hey, this is wrong, right? Like, this is, we were just fighting the system, understanding how unjust the system is, right?
That's right.
And so it's it's a shift in thinking for a lot of folks, I think.
That's right.
And so I want to talk a little bit about this tension between, or at least when I was in law school, there was a tension between, or decision you had to make between whether you wanted to do direct representation or whether you wanted to do systemic work, right? And I wanted to represent clients. I wanted to like stand by somebody, in the worst moments of their life and say, hey, you have to go through me before you do anything to this person, right? And other folks wanted to change, policies and systems, et cetera, right? And when I got to PDS, I really saw how, make systemic change, even in direct representation. And I love how you kind of exemplify that, right? And in involving your students in all these different types of projects, you incorporate, involve your students in these different things, because I think it shows them that you can have an impact, right? Like you can be involved in direct representation and all of these other types of systems change. So what advice would you give to law students, practicing attorneys, clinicians who are still trying to figure out the balance, right? How do I represent clients, but also, like you said, blow up the system? Like we got to blow this up, right?
So I think I get this question a lot, actually, from students themselves. They come into my office, they want to talk about the future. And the first thing that I say, this is a very personal thing, but it means I think it means something, which is that we do better as policymakers if we've been on the ground and if we've seen it. And so what I usually recommend to a student who's asking that question is that if you want a lifetime of policy and reform, then I urge you to spend at least 2 years, on the ground representing clients, or whatever the parallel is. You really understand how the system works and how real people are impacted. Far too often, we have policymakers, legislators who are making decisions about, to be quite frank, Black and brown people without ever having visited a Black or brown community, right? Or talking about criminal justice reform and haven't spent meaningful time in a criminal court. So that's my first piece of advice. That said, like, how does somebody, once they figured it all out, like, how do you do both? And one of the things that I also say is that I always remind our students and folks when I'm out, training, that our individual advocacy, individual litigation strategies do affect systemic change over time. Right. So this conversation we were having earlier about how race is relevant to the Fourth Amendment, right? It starts in individual cases where lawyers see and litigate and name how race is relevant into these critical inquiries. For example, whether or not race and the traumatic effects of policing in Black and brown communities undermines the validity of a consensual search, whether or not a Black child can reasonably or fairly consent to a search when a police officer walks up and says, hey, can I search you? And I would argue the answer to that is no. No reasonable Black child today could possibly think that they were free to leave or they're free to decline a police officer's request. And so that starts as individual advocacy. But as all of us defense attorneys across the country continue to push that narrative, like push that legal argument, we can also then, right, talk to lawmakers and say, you know what, as a matter of law, you all should legislate, you should pass a provision that says there shall be no consensual searches for children, period, of any race, right? Because of all the things that we know about adolescents. And we're seeing that, right? We're seeing slowly states, a few states are beginning to push that narrative. We think about what constitutes reasonable articulable suspicion, right? We have a whole laundry list. Well, we can actually, by legislative action, remove certain factors from the litany of what's an appropriate consideration for reasonable articulable suspicion. So in the District of Columbia, the smell of marijuana is no longer appropriate consideration for reasonable articulable suspicion. You could take flight off the table. Say running from the police is no longer reasonably understood to be consciousness of guilt. You can do that through individual advocacy, but you can also set the stage for that for legislative reform. So that's just an example of how our individual work carries over. And then, thinking about, ways in which we as litigators are watching, we're still in the courts day to day, how can we make broader difference through writing op-eds, right? Paying attention to what's happening in city council, paying attention to pending legislation so that we can, make ourselves available to testify, right? That means having meetings. We here in the District of Columbia, in our clinic, in a number of the clinics in DC, which I love, the lawmakers will come by. Our city council members, sitting right here in the office. So stop by. Hey, Professor Henning, you got an hour. You want to chat about blah, blah, blah. Yes, let's talk about it. And we talk about the provisions, right? That's what's happening by by making yourself available, showing up, and say, hey, this bill is pending. Do you have time to meet with me? And then 2 years later or 3 years later, they're knocking on your door. You don't even have to go find them. They want to ask you for your opinion. So I think we do that. And I'm, still as a defense attorney on the ground doing that work. And partnering, right, with ACLU, the Sentencing Project, or other, nonprofit coalitions, grassroots coalitions who are pushing this agenda, I think is one way in which we do it. So again, I'll stop there, but that's how we can do it while still litigating.
No, that's all. That is all just, I think it's so important to just be connected to all of those realms, right? It's so
Yeah.
easy to, live in DC and not know what is happening in those courts, right?
That's right.
And I think, approaching it from all of these different areas, just highlights the issue even more and increases the possibility that people are going to do something about it. So
That's right.
I think that's great.
Hi, Joe. So I know that Professor Henning has to go and teach class in 17 minutes. So I want to make sure you have time to do that. Joe, I don't know if you had like a really fast question or a comment before we wrap up, or you're just saying hi.
Can he hear us?
I'm not sure. Maybe not. Okay, so I just really appreciate your time and want to thank both of you so much today. We did record this conversation and we will make it available on our website along with previous conversations. Eventually they go through a little editing. We'll check with you to make sure it's all good. And we'll plan to re-engage with you all next semester. In the meantime, if you do want to check out recordings, I just put a link in the chat. Another plug for UDC Law. If you're in the DC area and you want to join us for our annual gala, it is coming up on November 17th. It is a fundraiser for our students, for scholarships, for summer support for those engaged in public interest work as well. So please reach out to me or any UDC faculty member for details if you'd like to join us in a couple weeks. But we're so grateful to you, Professor Henning, for sharing all that wisdom and knowledge. It's really inspiring what you have done with your career and what you were able to share with us today. Thank you for all that you do.
Thank you, Lindsay. Thank you, Ieshaah. It was fabulous.
So
I
much.
love being in conversation with you both, and thank you for having me.
Yeah. Thank you. Thank you, Professor Murphy.
Thank you all.
Take care.